Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike-Umegbolu, the host of Expert Views on ADR Ever video podcast show, and I'm delighted to welcome Mr. Ben Hayward to the Ever Show. He is an associate professor in the Department of Business Law and Taxation at the Monash Business School, Monash University. He is admitted to practice as an Australian lawyer in the Supreme Court of Victoria. He has published on private law and public law topics in Australian and international journals. He has also presented his research at conferences in Australia and beyond. He wears many hats, so I've left the link to his profile. Welcome to the show, Mr. Ben. Let me stop sharing now.
Thank you so much thanks for having me.
Yeah. All right. So without further ado, the first question is, what is arbitration and its role in dispute resolution? Thank you.
Thanks, Chinwe, and it's a great question to get started with. When I think about what arbitration is, I sometimes think about a note that Gary Bourne gave in the introductory chapter to his textbook, where he says there's almost as many different definitions of arbitration as there are people who write on the topic. For me, in terms of what its role is in resolving conflicts, I like to think of it as one aspect of the toolkit for resolving disputes, sitting alongside mediation, litigation, and all the other different forms of dispute resolution that you mentioned in the introduction. And in terms of what it is, well, I guess we can say it's a form of dispute resolution where parties agree to refer their dispute for resolution to a neutral third party or more than one third party. But it's a bit hard to get more specific than that because, for example, if we say, is it ADR or not ADR? Well, it's determinative, like court proceedings. So some people say it's not, some people say it is. There's all different subject matters as well. So we see around the world investment arbitration, commercial arbitration, employment and consumer. In Australia, for example, we don't have employment arbitration or consumer arbitration, but there is elsewhere in the world. Some people say arbitration is about finally determining results, but in some places you can appeal against arbitration awards. So that's not necessarily the case. And some people add to the definition resolving disputes according to law. But again, there's some exceptions to that. It's not used very often, but you can have arbitration decided on fairness and equitable principles instead. So yeah, I guess I like to think of it overall as part of the dispute resolution toolkit amongst all those other means that we mentioned at the start.
Yeah, because we've had so many people on the show that have said, oh, well, it's not actually on the ADR spectrum, should be on its own. And it shouldn't be with litigation. So it depends
on a
lot
of different perspectives on that.
Perspectives, yeah. So thank you so very much for highlighting that and also giving your own perspectives on what arbitration is and its role in conflict or dispute resolution. So the very popular question on this show is, how has it enhanced access to justice in Australia? Specifically in Melbourne?
Yes, the Melbourne location in particular is interesting because we have an institution in Victoria, in the state of Victoria in particular, called Arbitration Victoria, and it aims to provide faster and less costly dispute resolution. And we know that sometimes arbitrations can be just as time consuming and just as costly as litigation. But in Victoria, we do have this particular institution that focuses on faster and less costly dispute resolution. They've done some really rough calculations. It's hard to be super precise, but they have suggested that for lower value disputes, maybe less than 250,000 Australian dollars, arbitration might be twice as fast and perhaps 33% cheaper compared to county court proceedings. So for us, the county court is the middle court in our hierarchy in Victoria. So it's a relatively young institution. I understand from its some of its representatives that I've heard speak at conferences and events that they're fielding inquiries regularly, and they do have one award that's been published. But that's just one example in my part of Australia in particular where arbitration might enhance access to justice.
So that's an interesting fact. I also wanted to find out whether the third-party funding has enhanced access to justice in Australia.
Yeah, that's a really interesting one. It's hard to know because, and this was actually new to me before I read ICA's third-party funding task force report. I didn't actually realise, despite being in Australia, that apparently Australia is the place where litigation funding originated. So I guess because it's been around here for a while, it's hard to do a before and after comparison to know whether more cases are being brought because of third-party funding. And I guess the other difficult aspect to knowing that is that there's not really any good statistics on how many arbitration cases are being seated in Australia. So the Australian Centre for International Commercial Arbitration released the, first complete set of statistics for their arbitrations a couple of years ago, and they suggested there'd been about 100 arbitrations that they've administered over a decade or so, but that still doesn't account for like ICC arbitrations that might be in Australia or ad hoc arbitrations. So it's just really hard to know because of the lack of the numbers. And of course, maybe some businesses use third-party funding for financial management purposes as well, rather than access to justice. So yeah, I guess as someone external to the third-party funding industry, it's a bit hard to know.
Okay, thank you so very much. So I think you mentioned earlier that arbitration is much cheaper and faster than litigation, because you find out in recent years that some scholars and there are so many debates about arbitration being the new litigation. So what is your, I know you mentioned it earlier. Can you sort of elaborate on that? Thank you.
Sure. So I guess, like you said, it's been said that arbitration is the new litigation. I've seen people say that courts are ADR in international trade, and other people say arbitration's the only game in town. I guess I like to think of it as one option in the toolbox for resolving disputes. And for some kinds of disputes, it'll be appropriate, and for other kinds of disputes, it won't be. I guess an example I was thinking of is arbitration is meant to be final, so you generally don't get to appeal, but there might be some kinds of cases where you would want to be able to appeal and get a definitive answer that might be able to set a precedent for other cases, like if you've got a dispute over a clause in a standard form contract. So maybe in some cases litigation is better suited, in other cases arbitration is better suited. And I guess if we help parties make informed choices, then they can choose the option that's going to work best for them. I guess in Australia, we've seen a couple of cases where even where arbitration might have been a good idea in the abstract, things still haven't gone completely according to plan. We had a High Court case some years ago now where the party that lost the arbitration tried to mount a constitutional challenge and argue that parts of Australia's arbitration law were invalid. That didn't succeed, but that still meant there was time and cost in dealing with that litigation. And there was another High Court case we had just last year as well, where the respondent in the arbitration argued that a third party should bear some of the liability. So there was a question about whether the laws that share liability between defendants in Australia can apply in arbitration. So sometimes a case that might seem straightforward for arbitration may still involve difficult questions that end up in the courts. But I guess, like I said, I'd like to think of it as one option, and it's going to be useful in some cases, maybe not so in others, and parties can hopefully make good choices about that.
Yeah, so it depends on the cases. Okay, thank you so very much. And I think you also mentioned about lawyers sort of advising their clients to, choose the appropriate method that suits their case or their matter. So I want to find out if in Australia, the lawyers, have they fully embraced ADR? Because you find that in some jurisdictions that have researched on Nigeria, UK, and also in the Caribbean, Trinidad, to be precise, you find out that lawyers are yet to embrace ADR. Sort of, they don't, they are not so eager to refer their clients to settle their ADR. So, what's the state of that in Australia? Thank you.
So my impression is that it is embraced in Australia, and I just remember back to my own time in law school. We were required to do a mock mediation, a mock arbitration as part of our law degree. So the importance of ADR was really emphasised through those processes before we even got into the profession. And I know in our civil procedure rules and statutes in Australia now, there's actually a requirement for parties to take genuine steps to resolve their dispute before coming to court if they can. So the courts and the legislators are sending a message to practitioners that ADR is important. And I guess in relation to arbitration in particular, there's such a broader awareness of arbitration in Australia now than perhaps 10 or 20 years ago. There's so many events, there's webinars, there's in-person events. People really have an opportunity to learn about it and get involved in more arbitrations as more happen in Australia. So yeah, I really do think that there's an attitude in the profession that embraces ADR.
Thank you so very much. How about different sectors like the energy sectors? Is there any improvement with arbitration being used in that sector?
Yeah, so there's an interesting example here in Australia about the energy sector. Actually, we used to have a specific arbitration institution just for energy and resources disputes. So Western Australia has a big energy industry, and in Western Australia there used to be, and I'll just make sure I get the name of the institution right, it was the Perth Centre for Energy and Resources Arbitration. It used to be its own institution that became part of the Australian Centre for International Commercial Arbitration in 2020. So it doesn't exist anymore, but the fact that we did at one stage have a centre just for energy arbitrations, I think indicates how useful arbitration can be in that sector. And I guess the other thing I was noticing when I thought about this sector in particular was the School of International Arbitration report from a couple of years ago that looked at energy arbitration and suggested that arbitration is a preferred dispute resolution mechanism in that sector across the world. So I guess Australia's experience seems to be consistent with that.
Sorry, thank you so very much. So out of curiosity, how is mediation compared to arbitration? Is it more popular?
Yeah, great question. I think I would say it might be more popular in terms of numbers of mediations, only because you can have mediations in so many areas of law in Australia here that you might not have arbitrations. So we have commercial arbitration statutes. We don't have consumer arbitration or employment arbitration in Australia, but you can have mediation of those kinds of disputes. So I guess mediation more popular, maybe just because it would be used in a lot more areas of law.
Well, thank you so very much for that. So how about have there been any recent changes in the rules by the Australian or arbitral bodies to enhance or sort of contribute to the effectiveness of arbitration in the region in Australia?
Yeah, sure. So, Australia's main international arbitration institution is ACICA, the Australian Centre for International Commercial Arbitration, and they last updated their rules in 2021. So they've got a set of standard arbitration rules and expedited arbitration rules as well. And the revisions at that time took account of a whole number of things that came in the middle of COVID, of course. So they provided for virtual hearings, and also third-party funding that we mentioned before was addressed in that rule revision. A range of issues that were kind of important at the time. And late last year, the institution announced that it was going to have another rule revision process. So that was late last year that was announced. There haven't been any new rules formulated yet, but there's a really wide range of Australian and international expertise on the committee that's considering the rules revisions. So I guess everyone in Australia will be watching that with interest to see what comes out from that process. But yeah, the institution does have a really good track record of regularly updating its rules, and this will be another example of that happening hopefully soon.
How about the data protection of parties and practitioners? Because you could see in recent years there have been several attacks, cybersecurity attacks on arbitral bodies in some jurisdictions. So is there any updated rules on that as well?
Yes. So I guess cybersecurity is something that's really in the public consciousness in Australia at large. We've had some really high-profile cyber attacks on businesses here, I guess as is the case everywhere in the world. As far as I know, we don't have any specific regulations for arbitral institutions, but we do have data protection laws of general application that could apply to institutions and businesses involved in arbitration, depending on if their requirements are satisfied. So one of the requirements under our Commonwealth law is that the entity has to have a turnover of $3 million Australian dollars or more in the last financial year to be caught by the law, but there is a proposal to remove that so that it will just apply to all businesses and all entities. So it's possible that our Australian general data protection laws will have even greater application in the future. And of course, there's data protection laws overseas that have extraterritorial application as well. So for arbitrations involving a European element, the GDPR may still have relevance here as well.
Oh, okay. Thank you so very much. I wanted to also find out about I guess we needed data to determine how many cases have been settled so far with arbitration. Could you say it's improving than it was in the olden days, before the popularization of ADR or arbitration in Australia?
Yeah, so I think there is some indication that there is more arbitration happening now than there used to be. So I mentioned before that ACICA's report said that over a 10-year period they'd had about more than 100 arbitrations, but more than 60 of those were in the previous 4 years. So there was an increase in the number of cases over time. And that's just the international cases. There's been a lot of cases coming to Australia's courts relating to domestic arbitrations as well, around the enforcement of awards from domestic commercial arbitrations. So I would guess that the fact that there's more cases coming to court for the enforcement of the awards probably suggests that there's more domestic commercial arbitrations happening as well.
Oh, thank you so very much. So I think it's sort of the same thing in other jurisdictions. There are more people using ADR, particularly arbitration, as well. So thank you so very much for highlighting that on here. I also want what is the future of international legal research via podcast, particularly on arbitration in Australia? Thank you.
So I must say this is one of my favourite questions that I've heard you ask on the podcast before, because it's something I think a lot about as an academic. So as you mentioned at the start, I research and teach in this area. So I use podcasts in my own work as a way to learn about developments in the field, find out about cases from other jurisdictions, but also something that I think that's most interesting is they let you hear practitioners and academics and other people's views, and I think that's what they can be really interesting for. So I remember when I was in law school, in our first semester, we had a talk about, making sure in your research you refer to the most appropriate type of source. And the example they gave to us is, okay, so imagine there's a court case and then there's a report, a newspaper report about the court case. If you want to refer to what the case held, you refer to the judgment, not the newspaper report. But if you want to have evidence of the public's reaction to the case, maybe the newspaper report is the appropriate type of source. And I think that podcasts give us really great insights into what practitioners think about particular developments in the discipline. So I think they're really interesting to refer to for that process, for that purpose. And otherwise, I find I learn about so many cases and new laws and amendments and things like that in my own research from listening to arbitration podcasts as well.
Thank you so very much. Because that's one of the advantages of listening to podcasts. It's you get the news faster, you catch it faster. ADR in different jurisdictions, which you might not have the time to cover reading via journals and articles, but with podcasts is easily accessible, and it's like in your hands, and it's also something that you could relate to. You could even reach out to the experts to get more perspectives on what's going on in that jurisdiction. So that's one of the advantages, and that's why I love to podcast as well. So thank you so very much for mentioning that.
Thanks for the work you do in this space. I think it's a really great way to share information.
Thank you, Dr. Ben. Thank you so very much. So the final question is, what is your advice for potential users and, of course, people wanting to pursue arbitration as a career or practitioner in that field as well? Thank you.
For sure. So in relation to users, I guess, like I mentioned before, I think it's really great to have an awareness of what kind of dispute resolution process might be appropriate for particular different circumstances, and knowing, I guess, so far as arbitration's concerned, that so many jurisdictions around the world, including Australia, have really good legal regimes to govern arbitration, good track records of enforcing awards, courts that understand how arbitration works and support it. So I guess to users, I would emphasise that in a great many parts of the world, it works really effectively to resolve different types of disputes. For people wanting to get involved in arbitration, I guess for me, I like to think about the fact that there's so many different ways to pursue a career in arbitration. And as you mentioned, legal practice is one, but there are other ways as well. People might find themselves being able to contribute to arbitration as an expert witness, or on the law reform side of things as well through, there's been really important work done in the UK recently by the Law Commission that led to the Arbitration Act 2025 there. There's opportunities to get involved in arbitration through academic roles as well. So for me, even though I'm an academic, I'm aware because people have told me that some of my publications have been used in arbitration proceedings, and I get the chance to participate in law reform consultations and consultations about arbitration rule reform as well. So I guess legal practice is what a lot of people think of, but there are really a large number of other ways to get involved in the arbitration process as well. So I guess for me, when I started out in legal practice, I realised I loved the law, but the day-to-day life of a lawyer wasn't for me, and I've found a way to be involved in a different capacity.
Oh, thank you so very much for highlighting that. I also want to commend you for the contributions you've made in the field so far. Well done. And
Thank you so much.
I also remember that I didn't ask you about the Arbitration Act. Is there a new Arbitration Act, in
Australia?
Yeah.
Yes, yeah, there is, and actually, I'm glad you've asked because I meant to mention it earlier. So Australia's arbitration acts are based on the unsatral model law, so a framework that's familiar in a lot of other places of the world. We have a federation in Australia, so we've got one Commonwealth Act that deals with international commercial arbitration, and then each of the states and territories have a separate act to deal with domestic commercial arbitration, but they're all based on the unsatral model law.
Okay. So, is there any amendments to the old rules?
Yeah, so there's been a series of amendments over the years.
Okay.
The biggest amendments happened from around 2010 onwards, where the 2006 version of the model law was implemented in Australia for international and domestic arbitration. It's been pretty stable since then.
Oh, okay. Thank you so very much. Oh, this is a masterclass of. I'm now aware of the recent changes made by the arbitral bodies and the recent changes with the rules. Arbitration rules in Australia, and also it has also enhanced access to justice, and from what you've said, lawyers have also embraced it. So thank you so very much for your insights and perspectives and the learning you shared with us, and I'm very optimistic that potential users would embrace all you have stated and opt for it whenever the need arises. Thank you so very much for coming on the show, Mr. Ben.
Thank you so much for having me.
All right. Thank you so very much. Cheers. Bye.
Bye.